when it comes to children's rights, I've delivered several lectures on the continent, and Ghana, I've delivered several of them. Then, when we come to gender equality, gender inequality, I have published a lot on those areas. The most important thing that we must do is that we talk about human rights. Human rights encompasses bringing all people at par. So you should not sit down for one to be disadvantaged, including children. That is why, at a point in time, when people were talking about the fact that defilement should come within the pre-bargaining, I am one of those who objected to it, because we are talking about people under 16 who have been defied by people. And we are saying that if the person can pay money, the person can negotiate and pay money, then the person can be given any form of sentence. When the law has prescribed that the minimum is 7 and the maximum is 25. So I've championed a lot. And if you look at my contemporary criminal law, I've discussed a lot on children's rights, who is a child, what are the rights available to them, a juvenile, where do they go. I've also discussed them in my criminal procedure textbook. So I've done a lot of work on inequalities, to how to balance inequalities to ensure that men and women, we are at par, and children too are protected because they are young. Thank you.
To follow up, so if I understand you very well, if a revised bill criminalizing child marriage and witchcraft accusation is passed, how receptive would you be to its implementation from a judicial standpoint? Thank you.
Thank you, Honorable Chair. Honorable Chair, why should we at this modern age talk about witchcraft? It has become outmoded. And the only country that I've seen it in their statute is Tanzania. And whenever it comes before the African court, we condemn them. We find them to be in violation of it. Then we talk about child marriage. Why can't we wait for the child to get education, to learn trade, so that in future, even if there is dissolution of marriage, the child can survive? Now the person is 14, 15. That is why I'm happy with the laws on the defilement. Because defilement, it is neutral, whether male or female, it is immaterial. Once you have sex with a person under 16 years, with or without consent, you commit it. But there is a gap between our law. So if you are of 16, that means the person is 16 and the person voluntarily have sex. That one, you cannot blame any of the parties. But the person cannot marry until the person attains 18. So at 16, you can have sex, but until 18, you cannot marry. What happens within that period, the gap? I believe in future we can fill that gap. If you cannot marry, don't have sex. So why can't we make it straightforward, 18 years? I think these are the things that we need to address. Thank you.
Thank you very much, Honorable my Lord. We passed the affirmative action bill last year, July, and since you have been a trainer, or you have been in the institution of the judiciary institution, I want to tease out your view on how you can, what do you think we should do to ensure gender parity in the judiciary? Thank you.
Thank you, Honorable Chair. The Judicial Training Institute has capacity to train the judges. But when it comes to the training, at times we are confronted with facility cash. That is the problem that we need. Because if you ask one judge to move from Kumasi to Accra for training, the person will come with the driver. The person will come with bodyguard. How do you accommodate them? It is the cost of the judiciary. But at times, the judiciary hasn't got enough budget to undertake these things. That is why at times you see donors coming in to help. But some of some of the donors to their donation. To me personally, when I was the director, judicial training, I rejected some of them. They will go to the CJ. Because why should you come and tell me to train judges on a law that exists in your country and it doesn't exist in my country? I will not train. So these are the important things that, so if judiciary submit budget and the training component, I will plead with budget. I will plead with Parliament that the training budget always preserve it for us so that we can get enough money to train our judges, to build their capacity so that they will be up to the task. Thank you.
Thank you very much. Honorable Chair, let me take my lord into the current trending global issues. Looking at climate litigation, such as, and let's look at the issue of Adjei forest, as the case has been limited in Ghana due to the lack of specific legislation. Would you support a right-based approach to environmental cases? And how would you balance economic interest with constitutional protection? Thank you.
When we look at our constitution, there are two provisions which talk about protection of the environment. We will find it in Article 36. Then we also find it in Article 41. That is the rights and duties of every citizen. And every citizen is required to help to protect the environment. It is a constitutional duty. Despite the fact that it falls within the directive principles of state policy, it is a positive action directing every person, every Ghanaian, every person in Ghana to help protect the environment. How do we protect the environment? There are enough laws, even though we complain that there are not laws. There are enough laws. What are they? Those in the Adjei forest. What is the rationale? Who has asked them to go there? Do they have license to go and mine? They are illegal miners, and we have strong laws that will deal with them ruthlessly. So we have enough laws, but what to me is remaining is about enforcement. We must enforce it. Those in the Adjei forest, they cannot fight the entire Ghana army. They cannot fight the entire Ghana police. Why can't they arrest them? If they arrest them and they bring them to court, they are dealt with, and they are sentenced to a number of years as prescribed. Here we are talking about deterrent and preventive. We achieve some of the theories in criminal law. So, Honorable Chair, what I would say is that yes, we need to fight it, and it is corrective effort, because the law does not say that only police should fight. It says that every person shall contribute to the protection of environment in Ghana. Thank you.
My last question, Honorable Chair. What 3 specific constitutional amendments would you recommend to modernize Ghana's succession framework? And if I may ask, for each of them, if you can explain the current problem and your proposed solution. Thank you very much.
Thank you, Honorable Chair. Honorable Chair, my first proposal will be the district assembly. That the position now, we are saying that it should be non-partisan, but on the ground, it is partisan. Why can't we be bold to say that this is what initially we intended to achieve, but it cannot be achieved, and therefore, you can go partisan way, because that may help. Because as it is now, we are saying that it should be non-partisan, but every assembly member, they will tell you that this one belongs to this party, this one belongs to this party. So that is my first one. And the second one concerns my own work as a judge. Judges sitting in court as additional judges. That one should be abolished. Judges sitting in court as additional. Because it is not done in any country. It is not done in any country. We have enough high court judges. Why is it that if there is a case to be tried by a high court judge, we ask a court of appeal judge to go and sit? We have enough circuit court judges. Why is it that if there is a case, before the circuit, we ask a high court judge to go and sit as additional. You know, that one, we are talking about human influence. And we must reduce it, we must curb it. I have examined almost all the constitutions in Africa, and I haven't seen in any country where they ask judges to go and sit in another court as additional. So if we do away with that one, because always when a judge from a higher court goes down to sit on a matter, the impression is that why can't we get a judge from that court, but we bring a judge from another court? So even the mindset alone, it speaks volume. They start talking about bias, whereas we have enough judges for the same court. So to me, that one should be abolished. It is my own opinion because of the constitutional analysis that I've made. I think it should be abolished. So having said about these two, I think it is enough. Thank you.
Thank you very much. I wish you the best of luck. Thank you.
Thank you. I'll proceed to give the floor to Honorable George Kweku Rickett Hagan, the Vice Chairman of the committee.
Thank you very much. Sir Dennis or Lord Dennis, I'm sure each of them will go. Congratulations. My question will be an expansion of the question that Mr. Speaker, that is second Deputy Speaker, asked. And he was looking at whether there should be some additional courts, constitutional courts to deal with issues. But I want to look at the entire court system or the entire judicial system. There are a lot of complaints that there are a lot of cases building up in our courts, and that some of the reasons is that we don't have the manpower to do the work. There are some inefficiencies that need to be worked on. There's another school of thought that thinks that we should automate our courts fully, or at least to a greater extent. And that is to bring in that the functions of the court were mainly based on some kind of a database systems and management to be able to move things much quicker, in the court. We do say that the wheels of justice grind slowly, but it looks as if things are grinding much more slower than they should. In your view, would you also share that view that we need to automate our courts or computerize our court systems to become efficient enough to move cases much faster than they are being channeled at the moment? Thank you.
Thank you, Chair. The court has passed through several stages to ensure early disposal of cases. We started with the scopists, that they will move fast. Then at a point in time, we saw that the scopist work was not also moving. So we moved to the next level. The next level was to promote automation. Automation, at times, staff will be working and the light will go off. The court becomes standstill. Now, the aim of the judiciary is to achieve the e-justice. And the e-justice, you cannot achieve the e-justice where you do not have dependable internet. Because number one, e-justice, we start with e-portal. Go to the website, you'll find everything that you need. Then after e-portal, then you move on to the second one, e-forms. When you need the forms, you just go and print. Then e-filing, you use the same form to file. Then after e-filing, e-case distribution, there will be no manual for the head of the institution to say that you judge, go and sit on this one, you judge, go and sit on this one. It should be automatic distribution. But we do not have all these things. Then after that one, then we move on to e-evidence. We take evidence, then we do electronic hearing. Then we move on to electronic judgment. We've been talking about e-justice, the e-8. As at now, to me, I don't think we have even achieved 2. So we need money to overhaul the digital system of the judiciary to enable us to use the equipment to dispose of cases expeditiously. Otherwise, manual, if you go to some places, you see handwriting. It takes some time. Then at times, apart from the handwriting, you get interpreters. All these contribute. So I think that it is the wish of every judge that the court will be fully equipped with the E8. When we have, it becomes even a joy for you to work under such circumstances. Because if you come to the African court, for instance, and we are working very, very fast, the number of decisions, even though apart from the president, the 10 judges are part-time. If I tell you that 1 year, we can deliver about 36 judgments within 4 months. So it is the wish. And I will still plead that Parliament, when we present our budget, please defend for us, don't cut, so that we can help to promote expeditious disposal of cases. Thank you.
Any further question?
Yes, Mr. Chairman, one more question. And this one is actually on a lighter note. I'm a bit curious about this. You realize that most of our courts, the ones that I've seen and ones that others have been, again, you did talk about energy, of course, power issue. But we tend to have, a lot of our courts don't actually have air conditioning or AC and these things. Where we have them, they don't work. But then we continue to wear our gowns and our wigs. So I'm wondering, I know it's a colonial legacy that the institutions like the judiciary guard seriously. But you realize that the Speaker has taken off his coat, and so are the other, the first and second speakers, and including the clerks. Don't you think the gowns, though they are legacies that maybe we treasure, it's a bit outmoded, that we should maybe start putting on our traditional stuff like the Speaker and others are doing? These things will be much more practical, or these clothing will be much more practical for our kind of climate than the colonial gowns that we continue to put on, and probably use them on ceremonial basis like we do in Parliament today. Thank you.
Thank you, Honorable Chair. Honorable Chair, the wig and the gowns, they have several significance. They have several significance. Now, was it 2012, 2013, 2014, there was a proposal that we should not be wearing wigs and others. And we found, in addition to what I'm going to say, we found that some people who were not lawyers were posing as lawyers. Because it's just a matter of getting this and that. You can go to any court, announce yourself, I'm Dennis Adjei, appearing for this one. But if you talk about Parliament, Parliament is just one. Speaker is just one. So I'm happy that Parliament has taken the bold decision. But for the judiciary, wherever you go, every court has its own robe. All the international courts, all the national courts. So to me, my policy is that, after all, it doesn't take away anything from us. It doesn't take away anything from us. What it does is that it sets you apart that this is a judge. Look at with his wig and gone. So to me, I treasure it. So, Honorable, I will not support your position. Thank you.
Thank you very much. I think that we need to repair the air conditioning.
Honourable members, lawyers who are wearing the wig and gown are not complaining, but non-lawyers are complaining. Is it because they have no opportunity of wearing them? Yes, it's now the turn of Osahin, Togbi Osahin Alexander Kwamina Afanyo Makins, the ranking member of the committee. You have the floor.